Good evening, friends. Though we started the journey in 2020 during the COVID times, and we thought that we should try to enlighten the society in terms of the legal aspects and the journey beyond that. And one point which always kept within our team of Beyond Law CLC, कि शायद वो दिन होए जिस दिन चीमा साहब सानू knowledge share कर सकन, court his court craft, presence of facts and legal, how it has to be done, has always been inspiring. But at the same time, जब inspire तो करते ही करते सी, तो aspire भी aspirations है चलती हैं सी कि sir तो session समझा जा सके, bail दा, criminal jurisprudence दा. But एक last stretch of imagination जे क्या होता सी कि criminal appeals, वो भी drafting, preparation and courtroom advocacy. Sir, एक minute. I think there's some issue with the net. Like I was saying, so it was always a dream, not for me, but for everyone. कि चीमा साहब तो समझ सकिए. और क्योंकि one of the issues every रहा जब criminal aspect the lawyers ਜਿਹੜੇ ਜ਼ਿਆਦਾ deal ਕਰਦੇ ਉਹ ਕਹਿੰਦੇ bail जितना मर्जी पा दो, it is the decision and the fate of the client. But is it so? And whether your drafting, your preparation, and your opening statement does matter during the all advocacy, especially in the criminal aspects. This will be the entire journey, and we will also we are happy to share that, as usual, today's speaker, Mr. RS Cheema, the Senior Advocate, has also accepted that he would be more than happy that if we get more questions at the end of the session. And as usual, we will not take the questions in between. And the session would be like we have been doing of late. It will be an interplay between English, Hindi, and somewhat, at some points, some semblance of Punjabi also, but that will be at the end. And we will take the questions that can be posted on the YouTube and the this Beyond Law CLC's chat on the Zoom. And thank you, Tanu, for connecting us with Mr. Cheema. And I'm so happy and glad that he's here. The journey of expressing the gratitude for Mr. Cheema can continue, but that's not the essence. Over to you, sir. And we are too glad that you have accepted our invite.
Friends, colleagues, ladies and gentlemen, Mr. Vikas Chatrath had a genuine grievance against me. I have been postponing this interaction for a long time. I had always had the desire, and he's been very lavish. It is understandable, so you can make reasonable deductions from all the compliments he's paid to me. Starting with the topic that we have today. The topic is very generic, very vast. In fact, too general. The hesitation is when you go onto an issue like this, the topic we have now worded like criminal appeals, effective drafting, preparation, and courtroom advocacy. We find it becomes very vast. In fact, we are in the danger of making it spread very thin. But I agreed with this choice. The reason is, of late I have been asked by the benches repeatedly that the young lawyers are not learning to know how to argue appeals. The art of arguing appeals is probably disappearing, and the kind of talk. So therefore, permit me to start with a personal note. When we joined the profession, my own 45 years journey, the conclusions are the most fascinating part of the profession which I have found is still the trial. But next to that, the most satisfying work is the argument of an appeal. When we entered the portals of the High Court, we dreamed when we will get a chance to file an appeal. You know, a new lawyer only gets a couple of bails, some miscellaneous petitions. He would usually not be trusted with the appeal. Your question may be why? Because when we went into the division bench courts to hear our idols and icons, we found that the hearings are very relaxed. The judges are wanting to unearth the truth. They are not in a hurry. And we thought one day we would be heard with this kind of attention in the appellate courts. I personally, like you, some of you feel that I have something to tell you. I myself was fascinated by persons who I can name. In my court, there was a trinity of great lawyers on the criminal side. They were Sardar Dara Singh, late Shri Jagannath Kaushal, late Shri H.L. Sibal. I also had the occasion to assist and sometimes argue on the other side with Shri Frank Anthony, with Shri Anand Narayan Mullah, being on both sides with Shri Sushil Kumar also. So, over the years, one has a fairly good idea of how the appellate jurisdiction has been evolving. And lately, I don't know about other high courts, but lately I have found I've been appearing in three high courts, which are, as you know, Punjab and Haryana High Court in place number one, Delhi High Court in place number two, and Himachal High Court in place number two. In Punjab and Haryana High Court, criminal appeals have virtually not been argued for a long time. The pendency is, in fact, threatening. And the real issue then is that when we were young lawyers, we would go here, the competent and the brilliant advocates argue and learn and set standards for ourselves. Today, there is no one. There was a period when people came to herd us. Today, there is a very little hearing in appeal. And the most scaring part is that because of the flood of the outstanding litigation, the arrears, the hearing is getting a beating. So I'll end and I'll raise repeatedly the issue of the dwindling hearing, the disappearing hearing in the appeal, and the hurry with which appeals are sought to be argued. That'll be the theme. Now, coming to the topic for today, as I told you, it's too broad and too generic. I have tried to demarcate areas from a practical viewpoint so that when you leave today, you have some points, some questions, some reservations about what I'm saying, and also some search for answers which we need to. So I'll narrow it down and demarcate it. We will find a bit of arbitrariness in that which is unavoidable. Now, let's first also define what the appeals are. Criminal appeals, as we understand them generally, and I would assume them to be for today's interaction, are appeals from a final decision after a trial. Why this had to be said is for the reason that when terrorist activities led to the enactment of TADA Act, we had a section 19 in that. And later we had that section resurrected in the National Investigation Agency Act, section 21. These acts now widen, or I would say narrow down, the scope of appeal. They say every order, direction, judgment under these two enactments which I've mentioned are appealable. In the case of TADA, it was said they are appealable under 19 to the apex court. In case of the NIA, which is still in operation, the appeal would lie to the High Court even for a bail, even for an order upon charge. I don't want to mince words to say that the real purpose of this exercise is to scuttle the path of the litigant because he'll find it much more difficult to approach a higher court. But for today's purpose, we would be dealing with the appeals from final judgments. Three broad categories I'll share with you. The first is the penal code and the acts, penal statutes like the Arms Act, and all, as you know, triable basically as per the procedure of CRPC earlier and now BNSS. The second category of appeals are Special Penal Cum Regulatory Acts, Insecticide Act, Drugs and Cosmetics Act, Negotiable Instruments Act, Essential Commodities Act. Third category, which I think I must share with you, which would be very close to the general run of criminal appeals from IPC, are appeals arising from convictions or also, let us say, acquittals from the Prevention of Corruption Act. I'll very briefly deal with, I'll confine today to the Indian Penal Code. As I said, I don't want that we at the end of the day just touch and go and leave nothing for our discussion tomorrow. But permit me to very briefly touch the appeals which arise from the special statutes like Insecticide Act, Essential Commodities Act, Drugs and Cosmetics Act. Two aspects you would have, because each one of them has different set of provisions, different set of rules. First is, normally these appeals will be highly technical in nature. Each of these acts would provide for certain acts to be done in a particular way, sales to be made in a particular way, transfers to be made in a particular way. Similarly, samples to be taken in a particular way. So when we are proceeding in these appeals, I'll take very short time to just dispose of that point. We would normally find one sanction in each of these acts. The competence or the locus to initiate proceedings is one of the points which would mostly be an issue. In some of these acts, there will be sanction, but I'll dwell for a few moments on one aspect on which we all need to be very well educated. Even our judgments are not very clear. Unlike IPC, which, as you know, does not have any direct provision, even under now the new act, provision for vicarious liability. These all acts have. For instance, you all remember more readily 141 of the Negotiable Instruments Act, 10 of the Essential Commodities Act, 31 and 33 of the Insecticide and the Drugs and Cosmetics Acts. Here, I have to share with you a general lack of understanding that we show both sides of the bar to understand these provisions. And in my own way, I have always placed these provisions side by side. I have found that these provisions can be split into, they're all copies with a little difference. These provisions are split into three. The first clause, I'm not calling them subsection 1. The first clause says where the offense has been committed by the company as well as the person in charge. And here the word now may be followed by and or, and the person responsible to the company for its day to day affairs shall be the accused. Now, this is important. He is a deemed accused. He is an accused by virtue of his office. He is an accused not because you have any evidence against him. He is an accused because the company has committed an offense, and because of his position in the control of the company, in the board, the law presumes. That is why then you have this followed by a proviso or by a subsection, which says nothing prevents the person concerned from showing that the offense was committed despite without his knowledge and despite due diligence by him. This gives the window from a presumption which becomes rebuttable. The second part is most important. The second part, which would sometimes be subsection 2 in all these acts, would say where an offense has been committed as a result of the connivance or negligence or knowledge of a company secretary or officer of the company, and a word occurs here, director, which is a source of much strength for the lawyers also, but also a source where people are wrongly involved, shall also be guilty. Now, the words here are important. The words are where it is found are shown that apart from people in the first category. So, here when you bring people in, the question is, are they vicariously liable? The answer is yes and no both. Yes, because they are prosecuted by virtue of the offices described: company secretary, manager of the company, officer of the company, director of the company. No, because the section says shown to have been committed with the connivance, consent, or this. So the only part I'll touch is that all of us must very, very deeply study these provisions, place them side by side. I'll lead to the second part of it. The second part of it is there are some subtle differences which are evolving in these acts. For instance, the first act which we enacted for prevention of food adulteration, which was itself called PFA, and also its later version, the Food and Safety and Security Act, they provide for something which is more rational, not the whole board. They say the company can appoint a competent person as a nominee. So, therefore, instead of the board people, a nominee could be included. Then, in the Environment Act, latest act, they said person especially entrusted with the task of compliance with the act. So there are now subtle changes in these acts which confine the liability to certain defined people who can be more broadly tied with. So I would conclude this part of it because I want to go on to the next issues. With this, that when you are dealing with these appeals, you will see the sanction and the competence. You would also see the involvement in terms of the vicarious liability or in terms of what I said has to be found, and rest of it would always be technical. Then I'll predominantly take you to the Arms Act, and as I said, the endeavor will be that we carry home a number of questions. So we straight away come to the drafting of an appeal. Usually, when we joined the profession, I found some people very, very meticulous in drafting. Usually, when there was no dichotomy between the arguing lawyer and the drafting lawyer, the draft was comprehensive. The draft went into the questions, but there was very lackluster drafting also. And the saying in the corridors of the High Court was you need a one line, one para memorandum of appeal against law and facts, and you have the right to fight it. Over the years, I looked into the nuances of drafting. So, what I found is the drafting will be as the appeal is. As the appeal is. Suppose you are drafting an appeal where you say your accused is entitled to self defense. Your lawyer might have made an oversight. He has not suggested to the witnesses that you have a right of self defense, or he has suggested to them, but at the stage of the recording of the statement of the accused, which in under CRPC of 73 was 313, it is not brought in clearly, or a defense witness has not been examined. You have to be careful in your drafting. You have to be at that stage in your drafting, be awake to the fact that tomorrow, when you're going to argue the appeal, there may be a technical objection that this defense has not been taken by you. Even though you would always remember, and this is the cardinal principle, criminal proceedings are not by their very nature adversary proceedings. Therefore, the formal errors made, oversights made, can be gotten over. But still, in terms of Section 105 of the old Evidence Act, what you know, only you can tell. So, therefore, we would see and we would have to add that under the at the stage of drafting, everything will depend upon what kind of appeal you are drafting. Suppose you are drafting an appeal under the Prevention of Corruption Act, and the allegation is these are real life situations which I faced, and that is why I relate it. Under the dichotomy or disproportionate assets case, the accused has a defense that these certain properties came to him by legitimate sources, which he has said in his suggestions. He has led evidence also. I saw his 313 in a Roper case. I found that the 313 was not correctly recorded, and it would be an issue tomorrow because the onus would be on him. So when I called him, he said, "This is not my 313. I was made to sign a blank paper. There were four accused." Now, here is the test for a lawyer. I said, I can't now blame your lawyer and I can't blame the court. So then I looked into the 313 carefully and I found it was all mechanically recorded. For every accused, it was said, Christian and you, Christian and you, Christian and you. That gave me the scope. So I would add then in my grounds that 313 issue. Similarly, as I said, on an issue of sanction, I said something. Or there is a document which I need to bring on record. Very often, we lawyers oversee, and we are faced with a situation where the prosecution withholds documents which are in its possession. Those documents are vital. They might tilt the very nature of the case. What do we do then? So, the second issue which we would like to or we should deal with is, do I need to file an application contemporaneously for additional evidence in the appeal? Why we said contemporaneously? We, Tanu Bedi, who addressed you the other day, we filed an appeal where our case under 304B was, here is a cassette recording which was placed before the court at the stage of the order on sentence. The court relied upon it, but the court committed the mistake of not getting it formally proved. So we had to make an application for evidence to be led because those people were old, some of them would not remain alive, then the appeal would be argued and we had to be unsuccessfully, though we tried repeatedly. So this is the second kind of precaution which you would have to do at the stage of drafting. A caution which is very important. What has happened with us is an appeal has come to you, the sentence is 3 years, the client has 3 days for suspension. You have some vital point. So I have also used and I have also tried to tell others, please, if you have to file an appeal in a hurry, file it, get the man's bail extended, but immediately before the limitation expires, please find a supplementary set of grounds. The last tip I'm giving to you is my copyright, but I have to share with it once I've been called here. What do you disclose in an appeal? Remember, your first critical reading of the judgment is the most refreshing reading you make. If you are cool, if you are reading that judgment with a relaxed mind, you will get an insight which you might never get. You'll pause at a para and you'll say, this story is nonsense. You'll write at the margins. So remember, your first reactions, if they are noted down, they may never come to you again. It has actually happened with me. I've thought there was something basic which missed me that day. What is that? And in some cases, it didn't return. Then I made a practice of noticing that down, noticing what my first reactions are when you're reading the appeal. But there is a bit of now strategy here. Should I put every small point in my appeal? My experience over the years is don't. Because you must put the point in, you must put the framework in, you must not put the detail in. Because what happens is, with the hurried hearings of appeals which are taking place today, a good state counsel comes ready with the answers to your questions. You are confined to that. He doesn't have to do his homework. Let him do his homework. Don't take away the element of surprise. So, when this is one copyright suggestion to you, that when you are drafting your grounds, very subtle points may be hinted only, they may not be detailed. Then, two more questions which in drafting are important. We are not no longer looking at the charge, neither we nor the judges nor the trial courts. This is unjust, this is contrary to law. To give you a very frequently occurring fact situation, in Punjab and Haryana, most judges frame a charge 302 read with 120, 395 read with 120, 323 read with 120 for everybody. So there are 10 accused, 2 are in conspiracy. They'll be charged with 120 be read with so and so, so and so. Those who have caused injuries, they'll be charged with 320. Those who have not caused simple injuries and are with others, they'll be charged with 320 and with so and so. So charges are often now framed very carelessly, casually. So you also have to, in cases which are tough, in cases which would require a very prolonged and sustained preparation and argument, add this. And last, here is in the draft, while you are drafting, is always in your note try to reach what is the key question. What is the key question? I always liken or compare a trial or an appeal to the writing of a novel. What does a good novelist do? A good novelist has the last lines of the novel in his mind by the time he has finished the first chapter. He changes it, but his framework is in his mind. That is the test of the appeal also. There is a Turkish novelist, Pamuk, who also wrote about the theory of the novel. He uses the word the center of the novel, the core. So, therefore, the most important thing, most romantic thing, more fascinating thing in an appeal is what is the core point in the appeal? That is the issue which you have to keep in mind. Then I'll take you to the next when you are preparing an appeal. I've partly answered this question. When we are preparing an appeal, please, howsoever busy you are, if you want to do justice to the appeal, your first reading of the appeal should be relaxed, like you are watching a soap opera, like you are reading a novel, like you are listening to music. You are not sides. You are not a defense lawyer. Remember that. You forget that you are a defense lawyer. You also forget, if you are in an appeals against acquittal, that you are a lawyer for prosecution and you are the appellant. The idea is be as neutral as possible when you are having your first brush with the case, because that will enable you to be objective, that will enable you to know your case in its most unbiased manner. So save your assessment from your own bias also. That will help you. That will take you to stage two. The stage two is read your appeal again, read the witnesses. Again, the second reading also would be a broad general reading. Then answer the question, do I have a good case? Or I have a bad case? Or I have a case which lies in between. As you go to the teasing questions, as you go to the depressing parts of the appeal, you will have to answer to yourself first the question, what ails the appellant? What is my most difficult, insurmountable obstacle in this appeal? What are the questions which I must answer and I cannot answer? Why I'm saying so is only a lawyer who has his critical insight intact, and only a lawyer who has the objectivity to see both sides of the case shall be able to deal with a tough case, much less with a bad case. So you must, according to me, when you are preparing, first do these parts. Second parts are, as the appeals are three kinds. One, some appeals are which are a single point appeals. When I'll go to the appeals actually dealt with, this will be easier to explain, so I'll not dwell. The second category is very close to it, some points. The third category is the overall appeal has to be seen. The evidence has to be seen. The charges have to be seen. The demeanor of the witnesses has to be seen. It's an appeal of detail. So, this is how you ultimately will prepare an appeal. So, you will prepare the appeal from the manner and the style in which that appeal is before you. If you are doing a murder appeal where there is the only defense of denial, where your accused say we were not there, we are falsely implicated, your way of preparation will be different. In an appeal where you are going with a version, a cross version, you will look at it differently. There, the perspective will be what detracts from the prosecution case, the probabilities will become more important. The logical surroundings of the case will become more important. The third category is where you say the investigation is defective, the best documents are not brought forth, the prosecution has withheld things. So, therefore, when you prepare your appeal, these three, four things will matter. First, as I said, prepare it objectively without considering that you are a party, that you are projecting and propagating a certain viewpoint. Second is when you've gone through it further, see which side according to you it falls. Then you still go further. You see that if you are now you are a partisan lawyer, you have to get a particular result. You want witnesses to be disbelieved. You want medical evidence to be put against the ocular evidence from that point of view. So there, the three kinds of things, as we all know, you will need is you will need to dissect the evidence. Two, you would have to see the expert evidence wherever is possible, and then the law as well. Again, we lawyers are very greedy people. If we think that the case is proved, we say the main offense is not proved. If we say the main offense is proved, we go further and try to break 149 and 34. These stages in an appeal should be clear in your mind. And the finest lawyers are those who know when they enter the court that before a reasonably competent bench, this is what they will be able to emphatically ask for. That realism about the appeal will eventually help you also build a kind of respect for your way of arguments in the court. Your words will not be taken lightly. So that is about preparation. Now we are coming to the next phase of the appeal. You are to argue the appeal. Now, the Allahabad High Court saying is the young man, somebody like me who had joined the profession, in fact, somebody like Tanu, over obsessed, was sitting reading. And an old lawyer came, said, Mohtarma, ये मिसल घर पे पढ़ा करिए, अदालत में जज का मुताला कीजिए. So an appeal is basically what the judge hears, what the judge listens, what the judge understands, and what the judge is eventually the manner in which he is going to respond. Therefore, sometimes we are placed in a position very first day the judge has come on a transfer, you are before him. But that's not generally the situation. We must see that court functioning. We must see the manner of judge's hearing. We must see that the judge wants a sequence or the judge wants a very brief overview in the beginning. We all have different ways of approaching. For instance, when a client comes to me, even in a very ticklish case, I just keep quiet, ask him to tell me his story, start asking my questions, tell him on these are the miles. That is the way a judge would also analyze, and the judges would have a style which they have evolved over the time. So, what we have to first determine is how does the judge proceed? Does the judge proceed in fact, once I talk of the lawyers with whom I worked and who I found were good appeal lawyers, but some of the finest lawyers would start with their file closed with an overview of the case. Also saying this is a case of eyewitness account. The eyewitnesses, we are trying to say the eyewitnesses are not natural. They are not deposing correctly over this. The other side is saying this. The key points are the delay, the FIR, the ocular. This could be one way. So what I'm trying to say is there is no hard and fast rule how you open your arguments, how you proceed. You would have to be very keenly watching the bench. And if you are a real diligent lawyer, you would form and correct your opinion about the bench every day, because that will save the court's time. Court really loves correctly the lawyer who understands. Even a good bench has a way. A judge, for instance, I remember a lawyer stood up. The judge said, You have a hard case. This. The lawyer got very upset, agitated. He said, My lords have pre decided it. So the judge said, sorry, we are paid to decide cases. We are just trying to tell you. So this is the crux of what we ought to know. When we are arguing before the court, we must know generally that we should appreciate, understand, and go with the manner in which the court generally decides with a lot of flexibility. Suppose you are reading, the court is proceeding, the judge wants you to read certain evidence, he's permitting you. What you would do very discreetly is you will the sentence which you feel is crucial to you, you will say, my lords, I'll return to this. This is the core issue. Like this, you go on noticing. Trouble arises when you have a bench which is really pre-decided. I'll give you some instances on that, which the bench is really pre-decided. The bench says, no, no, nothing doing. How then we deal with the bench? That is where we will come to what I would say the aid of the case law also. Before that, let's try to answer the question, what makes a good or a very good or a brilliant lawyer? I think I've already answered the question. A man who has prepared his brief fully, but who knows that he doesn't have to start from A and go to Z, nobody will allow him. Who has the flexibility to come back and forth, spell out the questions, read the mind of the court, and then answer the questions. But on the more difficult part. The more difficult part is the benches, which this is a phenomenon we are all increasingly facing now. Benches feel arrears are too many, cases are piling up, matters are not being decided. Even at my stage, a very fresh judge says, Mr. Cheema, no reading of evidence. Now, according to me, it's illegal. It's unconstitutional. It is not done. It is not a judge's job. But sorry, don't tell that to the court. Try to steal your hearing. Try to persuade the judge. So I'll just some of the typical ones I'll share with you. The questions. First question is, this happens from the trial to the Supreme Court. Judge says, your client is an old hand. He's a habitual criminal. He's a repeat offender. Oh, no, 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 no. You are still serious about this appeal. So then you quietly say, my lords, he is, but my lords are open to conviction. And then you make the judge very quietly read, get somehow artistically make him read section 54 of the Evidence Act, which is now section 49 of the Sakshya Adhiniyam. It says previous character of an accused is not relevant except in reply. So you have to say, my lords, unfortunately or fortunately, the lawmakers knew that even a rogue, even a scoundrel, even a confirmed criminal is entitled to a fair hearing. I often use the sentence, my lords, he is an habitual offender. We are not habitually unjust court. We are a just court. So I'm only saying when these things face you, it's really tough for a young lawyer. His legs start trembling, and if he's not heard, what does he do? The second question is again something we all. It's a heinous crime. A little child, you've chopped off the hand, the legs are chopped off, nothing doing, and the bench is really dead set, single bench, DB. Then you say, my lords, your lordships are open to conviction even in the worst cases. The crime has been committed, but what my lords are trying to look at today is, has he really done it? Then the next question. Then again, you probably will have to be ready. This is the next part of today's talk when you need the case law. So you will start from 1952 Kashmira Singh and tell the court, my lords, their lordships have been holding the more heinous the crime, the more repelling the apparent conduct of the people who perpetrate the crime, the more careful, the more cool, the more composed the court is. So this is the second kind of roadblock. Third kind of roadblock is there is an eyewitness account against you. It's a broad daylight occurrence. They are not inimical to you. Why are the witnesses deposing against you? It's most frequent, even very moderate judges saying that. You have to be ready with judgments. There is an Odisha full bench. There are two other full benches, but there is Senior Chandrachud's judgment of the Supreme Court in 1981 in Shankar Lal's case, which says, please don't ask this question. You have numerous reasons why people involve others. You don't put the burden on the accused of this. So these are the questions which are put to you. Now, when you argue a case of a dying declaration, there are certain myths. One of the myths is a dying declaration has been recorded by a magistrate. How the hell can it be wrongly? There could be no error in it. Number two, a dying declaration. It's a sanctified document. It's a statement which is made by a dying person. Truth's lips stands at his lips. Truth is there. So therefore, the court says, don't waste our time. Don't waste your breath. What do you do? Again, way back in 1925, there was a judgment known as 25 Law, 1925 Law, Bakshish Singh, where the learned judge, an English judge, noted that the tendency to make a false dying declaration is prevalent in the state of Punjab. Interestingly, somebody went to the Supreme Court for getting these remarks, this also. But the judge was very deeply correct. It was an anthropological trait that suppose your son has been hit by a boulder and you have an enmity, in your tribal revenge, you will name. So then, but it didn't stop there. In Lakshmi versus Om Prakash, the Supreme Court dealt with a case of a lady, of a woman. The case was that it is possible that a woman in a revengeful mood, in frustration, may name somebody falsely. There's a Bombay division bench also. So you have to say, my lords, courts have experienced cases, they have come across cases, they have said that a dying man may make a false declaration. Again, for being persuasive, you will say it might happen rarely, but your lordships will allow me to build up a case. And since my lords have a view on the other side, all the more reason to give me a chance. That is how you have to open the door of a hearing. These are the cases when you have opened the door of a hearing. These are situations which we must know. Again, you would normally know the mood of the bench. Here I would come with a experience, with a time-tested experience, which we have over the years found to be very useful. The time-tested experiences go with a written note of arguments. Pass it on to the judge so that the judge knows there is a homework for him to do. There are arguments which are in cold print, which have to be answered. But when you go to this, don't offend the judge. You make your notes in, sometimes I do it in three phases, very brief, moderate, lengthy. Remember, you might have a situation where you don't get a hearing and you have to do your best. So be ready for that. This is about the arguments of the appeal, how you argue an appeal. But in the appeal, also remember, sometimes judges are human beings. You're making an argument. That's your best argument. It's not silly. If you are a cool and composed lawyer, stop there. Your Lordship may hear me on other issues. We'll return to it. Save your argument. It has happened with me personally many times where the judge would eventually hear you on 3 points, but your point number one, which has been rejected, was the best. So, flexibility in your arguments in appeal, your capacity to play cool, withdraw an argument for a later point of time, raise it in a different manner, that is where language helps you. And here, one most important quality you need is sense of humor. Sense of humor would always sail you. You would probably say, my lord, maybe I am obsessed that I have a good appeal. But for the sake of satisfying me that I've got a hearing, my lord will give me some time. Sometimes a thing of this time, a couplet, a joke, anything. That is something which you would need to buy patience from the bench. I'll then move on to very briefly about the TCA appeals because I'm not wanting to answer a particular question paper in the examination. As I said, I want a certain takeaway set to be with you. On the Corruption Act cases, I have found when we deal with, first say, majority cases which we do are either trap cases or DA cases. Scam cases are the third category which are arising. Scam cases are much like the IPC cases, details, evidence, rebuttals. But the trap cases and the DA cases are kinds which have a peculiar flavor of their own. They have a sameness where you attack those points. They are the sanction. In the DA cases, the most important thing is you almost have to be trained like a chartered accountant. It's a balance sheet. And again, the probabilities factor which will help you. Whereas when you go to a trap case, the basic point that the police has, the investigating agency has a vested interest in making a trap successful. As you know, the law continues to develop. Possession, 9/10 of proof, case proved, presumption cannot be rebutted. These are the issues. But primarily, you would have to go on the unnaturalness of the story, Malafides elements. So those are the things I don't think which will need a detailed discussion by us today. I'll now go to a feature which is very important. Does a busy lawyer, reasonably busy lawyer, or a young lawyer need a set of a register of his own, a record of important judgments which he should keep? For instance, I have for circumstantial evidence set of judgments which I feel are very good. I have for dying declaration set of judgments. I have for identification set of judgments which I've found good over the years. Years. I am putting a question to you all and to myself also. Is it a necessary tool with a lawyer? One is to look at the tool from a commercial point of view that I've told the judge. Look at it more deeply. Judgments actually teach you the soul of the law. So there are foundational judgments which I think we must all know, read them, reread them, treasure them. I'll recount only few of the judgments. In 1984, we had a three judges judgment, which is titled as Sarda Bidichan. It was the death of a young lady, Manju. It was poisoning. In one single judgment, the Supreme Court, all three judges, incidentally, very bright, wrote separate judgments. Justice Fazal Ali, Justice Vardarajan, even Justice Savyasachi Mukherjee. Old letters, whether they are dying declarations. So, five questions which it answered was a death by poison, when it is murder, what are the conditions? What is a dying declaration? Is an old letter mentioning it a dying declaration? What are the basic cardinal rules of a case depending on circumstantial evidence? What is the effect of some circumstance under 313 not being put to the accused? Can a false defense or a wrong answer given by the accused be the basis of the conviction. So, in one judgment you read and you get to know to the bottom of a number of cardinal principles. A judgment which will deal with suicide, psychology of suicide, deals with two books. One book says melancholy marriage, the other is on this. So these are my suggestion and request to all of you is foundational judgment must be read, they must be reread. They tell us what the soul of the law is. The second judgment, which I'll mention, which you have all heard but not read and reread, is Virsar Singh's judgment, 1958. Vivian Bose's judgment, a classic which was followed by Rishpal Singh, which tells us how murder charge is proved in a case where I have caused to A an injury which is sufficient to cause death in the ordinary course of nature. It says what is the subjective element, what is the objective element, how it is brought. A shorter judgment is difficult to conceive. This third is very important. That is the interplay of defense evidence or burden taken by the accused. The situation normally would arise in cases like cases of self-defense. The law, as you remember, I'm sorry, I'm referring to the old 105 Evidence Act, says where the accused pleads their exception, the burden of proving the exception is upon the accused. It is a simple line, but jurisprudence has made it a very fascinating part. Allahabad had one full bench of 7 judges called Prabhu versus the Emperor, 1941. The judgment went to this point. The issue was, does the initial onus on the prosecution transfer itself? The prosecution has to prove its case beyond a reasonable doubt. The accused has set up a defense. He's not been able to prove it. Does the prosecution burden shift? They said it never shifts. Two is, accused has not been able to prove his defense, but he's brought some valuable evidence. Does the evidence disappear now because he's not been able to discharge it? Or it's part of the record and has to be seen? And third is, with the evidence which the accused has now brought, the court has a broader picture. And in that broader picture, though the offense is proved that some offense is committed, but for the offense charged, an ingredient is missing. Suppose it was 302, it looks like 302. This was done in the second judgment of 9 judges of Allahabad High Court. These are great judgments, which is called Rishikesh judgment. M.H. Beg, who later came to the Supreme Court. And Supreme Court followed it in Vijay Singh's case. And they went back to. So these are judgments which really give us, they fascinate us, they teach us, they make us people who know their jurisprudence. These judgments have to be read. In this small list, I think we are running against time. I'll also touch judgments on probabilities. 1954, Supreme Court was dealing with a case where in a railway compartment, it was a revision. Normally, they would throw it out of the window. 3 courts have dealt with it. The allegation was, while all people were sitting, family was sitting, the man who was the accused, he had committed an offense under 354, outraging the modesty of a lady. There were injuries. Supreme Court at the apex court at that stage said, no, we are rejecting this. This is too much to accept. This is against probabilities. So these judgments on human probabilities. The other one is Selvaraj judgment, 1976, which must always be part of your arsenal. These are the judgments which I believe you must have. Now, Tanu Bedri is sitting here. One judgment which she got, I was the person who booked the case. It was a pilot in the Afghan Airlines who was caught with a heavy quantity of contraband by custom authorities at Amritsar. So I, like a seasoned lawyer, seasoned lawyers sometimes become old surgeons. They say, no, no, incurable, no chance. So I put it in the category of a tough case. Fortunately for my client, I did not do it. I became Advocate General. Tanu Bedi raised the larger issues of I'm not going into the technicalities, larger issues of reverse burden, like in 304B, there's the presumption you have to prove innocence. She went into the issues of fair trial. She brought in, this is all before the apex chief, she brought in the international covenants. Then she brought in the value of the three, four things. Number one, that the mandatory provisions were not strictly complied with. Independent witnesses were not examined. All material which could help the accused was not brought on record. Now, this all singly has been rejected in hundreds of cases, but she, with her both preparation, perception, and capacity to totally bring it before the court, was able to get a surprise acquittal. And in an NDPS case, which unfortunately I think has not been followed to the extent it should have been, because we come with the obsession that Chitta is destroying us, therefore anybody accused has to be hanged. That one judgment eventually showed that everything that you look at, you have to look at from the broad perspective of a fair trial. That fair trial is the civilizational foundation of rule of law. So that's another judgment which all people who are dealing with that law, they read, which you must all read. I don't know how much time we now have. Hmm?
Sir,
So
time की कोई
5
कमी
minutes.
नहीं, you are, नहीं time की कोई कमी नहीं, you have mesmerized everyone.
How long can we continue?
So they say
10 minutes?
once they are good things, you shouldn't stop.
Can we go on for 10 minutes?
Yes, sir, of course, of course.
All right. I'll now deal straight away with cases which I did. My friends, young friends hearing it would know. One case we did was about two CRPF Jawans. But they were drunk. One fired a shot, the other died. It was a close range shot on the abdomen. And the man took the defense that this man came with a gun. He was going to fire at me. I snatched the gun and fired at him. The plus point was it was a close range fire. The plus point was the gun had been issued to the man who died. But the minus point was very interesting. The judge knew his ballistics very well. Judge said, look, if that man has come close to you and he has put the barrel at your abdomen and are nearly there and he has fired, the entry wound should be round. It should not be oval shaped. It should not be oval shaped. On that one very bright idea, the learned judge said, no, you are convicted. The case continued to disturb me because in the overall situation, and what I brought in is very interesting. I remembered that when we were playing as college students basketball, we saw people who were very well built, who had six-pack abdomens. And we found that when people are bending, even if they are the fittest people, their abdomen shrinks. And if you place something round there and a shot is fired and the man is then brought, the wound will be oval in shape. So on this short point, I brought before the High Court, I said, how can you decide it on all these points? The abdominal man, when two people are bending, one is snatching, that man is bent, his abdomen will have folds. In those folds, when it reopens, it will be different shape. So that why I'm telling you this story is you must sleep with your case. Your case must bother you. The result would be different. I'll tell you another interesting case. We did a case of murder where the man was thrown into a well. He had number of injuries on him. The well had a present day motors put in, lot of wiring, lot of strips, iron strips, and the man was behind the bars. The man's Perokar said, this is not a murder at all. Not that we have not committed it. So when they repeatedly said it, there was a defense very vaguely taken of an accident. But the court said so many injuries, all incised wounds. When they repeatedly said it, I very minutely studied the injuries. So I found, if you can see my forehead, an injury starting from here, passing through all the forehead front, also cutting the nose between half the this, something, an injury which is impossible for a man to give with a kirpan or with a weapon. And there were all injuries were from, they were vertical in nature. Then I looked at the maps. The maps showed that the well had a number of protruding objects. It had stripes, it had stripe edges. And I said, how can it be that a man is attacked, all his injuries are vertical? And the bench looked at it medically. And eventually, the benefit of doubt went to the accused. The story is not to tell of my achievements, failures may be far more. The story, the experience is being narrated to you only to tell you that you have to dwell with the appeal, you have to be living with it, you have to be sleeping with it, and then you have the passion to defend cases. There are two more cases which, so that you don't go home bored. One case is in Kurukshetra, there was normal tamasha which is there on melas going on. One of the tricks that Jamura game was, the Jamura is lying down, a huge stone is placed on his chest, and the master breaks that stone with a hammer stroke. This is something I've seen myself happen. As layman, you are very impressed that the man sitting below is not hurt. The undergoing principle is, if he doesn't move, he doesn't get hurt. Here the man died. There was a 304 conviction. And you know who got me the acquittal? French author Maupassant. You will say, why the French author came here to argue the case? He was a short story writer. You must all read him. He wrote on a varied kind of subjects about Trumps, accused, everybody. He wrote about a trickster, a juggler who was famous all over France. People came, he showed different tricks, jumping through a ring which was on fire, etc., etc. The last trick was very interesting. The last trick was his wife, who was very beautiful, green eyes, she would stand against a board. He will take a set of knives and go on throwing the knives like he's doing it casually, and they would go close to the body. He will reach here. That is now when he'll put his hat and people will put money. And these last two knives would be the entire France remembered him, saw him. So one day he over the last tours, he had a young boy who would join him as a pupil. He started drinking with him. He says, what have you seen the expression in my wife's eyes? He says, no, no, she is not afraid because she knows you are a master. He says, no, she's unfaithful. She's smiling at me because I can't do anything. He says, why don't you kill him? He says, I am the most safe killer in the world. If one of my knives goes inside the neck hair, nobody is going to charge me. He says, why don't you do it? He says, these are not my hands. They are the hands of an artist. Many a time I've tried to throw the knife here. It doesn't go there. It goes where it ought to go. So I told the judge, I said, here is a man, we are wanting to see that he's an accused, who's done this trick thousands of times. He knows the scientific basis is this. The error is of a different nature. So that persuaded the court. The idea behind the entire exercise is there are many other interesting cases. So at the end, I'll just give me 2-3 minutes. As people who are now going to go into the profession, we were romantic about our heroes. And from the three I've named in my court to the others, Ram Jethmalani, I assisted in many cases. I am very worried about disappearing hearing in the court. That is on the side of the bench and the areas. But I am also very, very disturbed about appeals not being prepared with the dedication that they need. Medical, ocular, other evidence, case law. So, therefore, please see, we are dealing with human lives, we are dealing with liberty, that we do not kill the institution of appeals being heard with a particular kind of solemnity. and being decided as justice would require. So thank you very much. If you have any questions which reach me, I'd love to answer them.
थैंक यू सर. आई वाज सेइंग कि फ्लो तो ये हुआ कि भाई हिंदी या पंजाबी में करेंगे, बट सर वाज सो चार्ज्ड अप विद दैट इंग्लिश, द एंटायर सेशन वेंट अप इन इंग्लिश. बट
चलो अब
द वे
जवाब हम हिंदी,
सर सर
अब
सर
जवाब हिंदी में दे दें।
सर ने इतना मेस्मराइज कर दिया कि वो लगा ही नहीं, क्योंकि वी वर ऑल एट ईज. बट द सेशन वाज सो fascinating. I had sent a separate text to Tanu that sir is just mind blowing. Sir, few questions which I have received separately on the chat. One is
Please.
one you have said already that once the case comes to file the appeal, you have said that just have a rough draft of that, how to go about it, and the evidence. Some people say कि भाई file तो immediately करना है, and you have said that supplementary grounds can be raised. One question was, is there any specific provision where you can raise these supplementary grounds? Number one. And number two, they say that in an appeal, you can all raise the issues where there is misreading of evidence or misappreciation of evidence, or whether that will be suffice.
So I think we can combine the two questions.
Yes, sir.
9 out of 10 times they are correct. All questions of fact can be raised. But suppose I am going to raise a question tomorrow which requires taking up further evidence. I want some document which is in the possession of the prosecution, which is not placed on record. Law is prosecution can be compelled. I want, like I gave that example, a voice recording to be done so that comparison can be made. These cannot wait. By the time, so therefore, number one, the question is technical in nature. There is nothing to stop supplementary grounds. Particularly, that is why I said if I am within time. The idea of supplementary grounds is that you give the other side an opportunity of meeting it and preserving the material which will form the basis of your ground. This is not a general practice. My friends may kindly appreciate it. These supplementary grounds are not needed in a normal case. In a normal case, all questions of fact and law are open. But questions which need additional material would require the material to be preserved, would require the evidence to be collected. So that is where a different exception will have to be carved out.
So second was, like you said, you create the margins, etc. And you said 3 types of notes. So I would just like somebody asked then in one of the sessions we also asked, जो 3 टाइप के नोट्स हैं, आपको उसको कैसे डिसाइफर करना चाहिए फाइल प्रिपेयरिंग द अपील? सर, एन एलैबोरेशन.
ये तो देखिए,
तो एवरीबॉडी हैज हिज ओन टेस्ट. एवरी
ये
विल
तो
मेक द
मुख्य,
कोड इन डिफरेंट वे.
आपको पते हो, आप ये सब जानते हो कि हमारे नोट तो हमारी कविता होते हैं, हम अपनी समझ से लिखते हैं, लेकिन अनुभव से जो निकलता है वो क्या है कि एक नोट वो होता है जो सिर्फ बहुत की मुद्दों को टच करता चला जाता है. इट आजकल कोर्ट कहती है 1 पेज का नोट दो, 2 पेज का नोट दो, बहुत बार नहीं हो सकता है. और 3 पेज का जो नोट मैं 3 तरह का कह रहा हूं वो कॉम्प्लिकेटेड केस में कह रहा हूं. वो है थर्ड, जो सारी एविडेंस को कोर्ट के लिए मार्शल करके रख देता है. मैंने ये किया, जो लंबा नोट है, दिल्ली रॉयट का मैटर है, अब आ रहा है, सज्जन कुमार जिसमें सुप्रीम कोर्ट में, हाई कोर्ट में कन्विक्ट हुए, बिकॉज उसका रिकॉर्ड बहुत बड़ा था, उसके क्वेश्चंस थे, कोर्ट ने आपकी बहस बंद कर देनी है, कोर्ट में 2 दिन दे दिए दोनों पार्टीज को, वहां आपको नोट देना ही पड़ेगा. और वो नोट 80 बार कोर्ट किया मेरे नोट से, रिटन नोट से, जज ने, जब वो अपील उन्होंने एक्सेप्ट करी. तो ये इसलिए ज़रूरी हो गया है क्योंकि कोर्ट्स पे टाइम का प्रेशर है और हमें अपने आर्गुमेंट एक गिवन टाइम में ख़त्म करने हैं. नोट बनाने का जो कला है वो अपनी अपनी है, समय से आती है. और ये जो 3 नोट कह रहा हूं मैं, ये विशेष केसों में कह रहा हूं. जनरली 2 नोट, एक नोट जो सारी सिचुएशन को डील करता है और एक जो उसकी समरी है, बुलेट पॉइंट्स देता है.
सर, अब नेक्स्ट क्वेश्चन जो रेलेवेंट जैसे हुआ, लाइक यू सेड यू गो टू द कोर्ट, कि one shouldn't be like Tanu engrossed with while making notes for her own case. But how do you say that you go ahead with the opening statement, जैसे, क्योंकि जैसे बेल है या अपील है, तो अपील तो फिर भी टाइम लगता है कि you start making an opening statement to impress and have the eyeballs grabbing.
देखो इसमें जो ये लॉयर है, मैं समझता हूँ जिस लॉयर ने अपने केस को तैयार करके डाइजेस्ट किया है, जिसने उसको एब्जॉर्ब किया है, उसी में ये काबिलियत आती है कि वो अपने केस को 2 मिनट में अदालत के सामने हथेली पे रख देता है, जिसको हम अपनी भाषा में कहते हैं हथेली पर सरसों जमा देता है। उससे माहौल बनता है। हमारे यहाँ जिन मैंने बड़े लॉयर्स का नाम लिया, सिब्बल साहब सबसे ज्यादा करते थे। फाइल बंद और आप बात सुना रहे हैं। केस को अगर कहानी बना सकते हैं आप, फिक्शन बना सकते हैं आप, तो आप जज को केस से जोड़ रहे हैं। तो वो मैं ये करने की कोशिश करता हूं जहां जज सुनता है। अगर उसने मुझे आधा घंटा भी देना है तो मैं 5 मिनट यहां से शुरू होता हूं, वो हेल्प करता है। जज आपको उसको समझता आती है कि मुझे किन चीजों पे फोकस करना है, इसमें कौन से मेन मुद्दे हैं, क्या प्रश्न है जिनका उत्तर देना है। ये लॉयर को ट्राई करना चाहिए। यही एडवोकेसी है। बाकी तो प्रैक्टिस की और छोड़ दी हमने, अध्ययन किया, पॉइंट उठाए, बोल दिए, लेकिन उस केस को मैं समराइज कर सकता हूं कि नहीं। मैं अपने ऑडियंस को चर्चिल की बात सुनानी चाहता हूं। चर्चिल बहुत बड़े वक्ता थे। उनको किसी ने उनसे टाइम ले लिया कि वो 2 मिनट बोलेंगे। तो शाम को चर्चिल पीने के बड़े शौकीन थे। उनका सेक्रेटरी उनको पूछता है, विंस्टन मैं तुझे कितने दिन पहले बताऊं। उसको बताना था। कहता है 15 दिन पहले। वो बड़ा हैरान हुआ, दुनिया का सबसे बड़ा वक्ता ये क्या कह रहा है। उसने कहा विंस्टन 2 मिनट। कहता है हाँ 15 दिन। बोला अगर तुझे 15 मिनट बोलना है तो कहता है 2 दिन पहले। और कहता है तुझे 2 घंटे बोलना है तो कहता है मुझे अभी शुरू करा ले। ये मजाक नहीं है, ये बहुत गहरी बात है। जितना आपको थोड़ा बोलना है उतना आपको ज्यादा गहराई से तैयार करना है। तो ये समरी जो है ये एक तरह से लॉयर की काबिलियत का, प्रेपरेशन का, एसिमिलेशन का टेस्ट है,
Sir,
जिसको गागर में सागर कहते हैं हम।
yeah. So the questions are pouring in, and thank you messages for your sharing knowledge is going on. Sir, one another thing is, uh, though you had touched it briefly, one question is, do you think drafting or oral advocacy, which will have better impact in the right sense?
Would you repeat the question,
Now,
please?
whether the oral advocacy will make more impact or your drafting will make, or it's a juxtapose of
See,
both.
no, at the end, it is oral advocacy. The drafting is for you. The drafting is your preparation, your first interaction with the case, and your insights into it. The advocacy is across the table. Your memorandum of appeal is not going to be consulted by the court. That is only when the court says, have you taken this point? Otherwise, it's not relevant. But your first brush, as I said, I have seen my first brush with the case is when my eyes are open, when I'm deeply interested.
This is what role does framing of questions of law play in securing leave to appeal in criminal matters?
That is all important. When, in fact, particularly when you're before the Supreme Court and you look at it in the perspective of Article 136, your entire skill has to be put on that, because I have come across cases which were cases of manifest injustice. The only category on which we put most of the cases are manifest injustice. And the court says in how many cases? So if we can find a legal issue, which we can sometimes find, it is most important when we are taking an SLP.
So this is like you are already attached this thing. It says what are the some effective technique, like you have said that you have done the Sajjan Kumar's case or a lot of voluminous cases. What are some effective techniques for cross-referencing for the trial court records? Because we are all running short of time. How can you chisel out the right facts?
Well, I have one who has been assisted by people. I'm sorry, you can't delegate. The art of appeal is art of the novelist. The novelist is the master of the detail. He goes into a wealth of material and brings a very short one for us. So reality is when I go prepare for an appeal, I only speak 1/5 or 1/10 of what I've prepared. I think that is one part we might make a collective effort. We might have a teamwork to do but we can't avoid reading. We can't avoid reading first evidence firsthand.
So, like I heard one of the sessions of Mr. Kapil Sibal, he said that as a lawyer, you are a person who should know the science, the history, the English, the communications. And I've also seen that during this entire session, and also we've been experiencing while you make submissions, though it's rare that we cross across the same platforms because we different traverse different fields. So do you feel your different fields की books जैसे आपने पढ़ी चर्चिल की इसकी it does affect your style of arguments, your style of drafting, your because they say कथा से ज्यादा कथाकार की जरूरत है और हमने देखा आप जैसे तो कथाकार बहुत ही अच्छे हैं.
सर बिल्कुल आप सही फरमा रहे हैं। असल में वही बात जो है वो रंग बदल जाती है अगर कहने वाले को कहना आता है तो। कहने का की कला, कहने का अंदाज जो है वो बहुत बहुत अहम है। बात को छोटी करना, बात को बढ़ाना, बात को अगर संक्षिप्त कर सकते हैं, जैसे मैंने कहा उस बात को पोस्टपोन करके दूसरी बात ले आते हो। एडवोकेसी इज कम्युनिकेटिव स्किल। कम्युनिकेटिव स्किल का एक अंग जो है वो भाषा है, और भाषा के साथ जो प्यार नहीं करता उसको एडवोकेट होने में रुकावट आएगी। क्रिमिनल में पर्टिकुलरली आएगी। हम करते क्या हैं, उन्हीं फैक्ट से पब्लिक प्रोसिक्यूटर एक इमारत खड़ी करता है, मैं दूसरी इमारत खड़ी करता हूं। इसलिए अगर कहीं अंदाजे बयां का या बात करने का हुनर काम आता है तो एडवोकेसी में आता है। तो लैंग्वेज, उसके आशय क्या है, उसके अलग अलग कनोटेशंस क्या है, उसकी नुएंसेस क्या है, यही तो एडवोकेसी है।
सर ये आपसे जब बात चली जस्टिस मुरलीधर की एक मैं ऐसे यूट्यूब देख रहा था, उन्होंने बोला क्रॉस एग्जामिनेशन जब हो रहा होता है तो आपने ध्यान देना है। तो जैसे उन्होंने एक एग्जांपल दिया कि उससे एक सवाल पूछा गया, क्या तूने मर्डर किया? उसने तो पूछा मैंने मर्डर किया, दैट वाज इन द क्वेश्चनर फॉर्म, और पर जब टाइप हुआ दैट इट वाज एन एडमिशन दैट आई हैव डन द मर्डर, सो ही सेड that it is also paramount to the fact that you should be very careful while the cross examination does, like what you said. मेरे को वो याद आ रहा है जो बहुत पुराना था, that in the sense it said कि भाई रोको मत जाने दो, जो बहुत पॉपुलर है, रोको मत जाने दो, that comma will change the entire essence. So two questions in the chat because I think that we will have to take an excuse from them because we did. सर अगर 10 मिनट के अंदर ये हिंदी में आप लोगों को समझा सकें जैसे हमने लोगों को कमिटमेंट की थी, शॉर्ट ब्रीफ, सिर्फ आर्ट ऑफ फाइल आर्ग्यूइंग द अपील, नथिंग बियॉन्ड दैट, और ड्राफ्टिंग व्हाटएवर आउट ऑफ द थ्री यू चूज.
सर 10 के 5 मिनट रखूंगा सर।
राइट सर.
देखिए ऐसा है कि जो अपील है वो बुनियादी तौर पे जो ट्रायल है उसका एक्सटेंशन है। तो जो एविडेंस ट्रायल में रिकॉर्ड की गई है, जो सवाल पूछे गए हैं, जो जवाब आए हैं, जो मुद्दे उठे हैं, वही हैं जो अपील में आप आर्गू कर रहे हैं। तो अपील में जो मोटे रूप से मैंने बात कही थी कि जब आप अपील को पहली बार तैयार करना शुरू करते हैं तो आपका माइंड जो है वो बहुत ताजगी से उस अपील को उत्सुकता से देखता है। तो उसके जो आप नोट बनाते हैं वो आपको उस अपील के बहुत जो सूक्ष्म पहलू हैं उनके प्रति जागृत कर सकते हैं। आप जब अपील तैयार करते हैं तो आप सबसे पहले ये प्रयास कीजिए कि आप एपेलांट के वकील नहीं हैं। आपका दृष्टिकोण ना इधर है ना उधर है, ताकि आप एक ऑब्जेक्टिव तरीके से, वस्तुपरक तरीके से अपील के दोनों पक्षों को, उस केस को, जो एविडेंस उस आरोपी के खिलाफ है, जो एविडेंस उस दोषी के हक में है, जो उसके इर्द गिर्द के वातावरण के साक्ष्य हैं, वो सारे आप एब्जॉर्ब करें। तो बुनियादी तौर पे जो मैं कहता हूं कि प्रेपरेशन अपील का अभिन्न अंग है। आप उसकी तैयारी कितनी गहराई, कितनी सघनता से करते हैं, ये तय करती है कि आप अपील में आगे कहाँ जाएंगे। बिकॉज मैं जो गाऊंगा वो इस पे निर्भर करेगा कविता किस किस्म की है। मैं बाद में जब शुरू करता हूं, कोर्ट में जाता हूं, तो अदालत मेरी तरह कानून के क्षेत्र में है, मेरे से योग्य भी है। तो मेरे वो पॉइंट काम आएंगे जो तथ्यों पे आधारित हैं, जो लॉ पे आधारित हैं। लॉ वो काम आएगा जो उन तथ्यों में से तालमेल बिठाता है। तो ये सारी चीज़ें जब मैं करूँगा तब मैं एक वकील बनता हूँ। और वकील जो अपील का वकील है उसकी कहानी अपील करने वाली जिसके खिलाफ कर रहे हैं उस जजमेंट के पढ़ने से, उस साक्ष्य के पढ़ने से, उस ड्राफ्ट को तैयार करने से, उसके बाद अदालत में जाने से, और फिर जैसा मैंने कहा अदालत का मुतालिया कि जज किस तरीके से फंक्शन करता है, जज के मूड क्या है, जज किस तरह की बात सुनते हैं, उनके पास छोटी बात रखी जाए कि लंबी बात रखी जाए, वो लॉ का क्वेश्चन पहले सुनना चाहते हैं तो उनको बताया जाए, उनके अगर कोई ऑब्जेक्शन है तो उनको संतुष्ट किया जाए। ये सारे यानी जिसको हम कहते हैं आर्ट ऑफ कम्युनिकेशन, जो संवाद का की कला है, वो बुनियादी तौर पे वकालत का आधार है। पर वो जैसा मैंने अर्ज किया वो आपकी तैयारी की सघनता पे, तैयारी की क्वालिटी पे निर्भर करती है। और उसके बाद जैसा मैंने कहा कि आपको कानून के बारे में पूरी तरह जानकारी रखनी जरूरी है, क्योंकि जब आप खास मुद्दों पे पहुंचते हो तो कोर्ट को आप बताते हो कि कानूनन इस बात का अर्थ ये है। जैसे मैंने बताया, आप एक लेडी के सुसाइड का केस कर रहे हो, उसमें 306 का दोष भी हो सकता है, 304 बी का भी हो सकता है। आप वो तथ्य इकट्ठे करते हो जिनसे आपको लगता है क्या ये निराश थी, क्या ये बीमार थी, क्या ये डॉक्टर पे जा रही थी, क्या इनकी जिंदगी में उदास करने वाले पहलू थे, क्या इनके घर में, इनके मायके के घर में कोई बात हुई थी, क्या वो इंसॉल्वेंट डिक्लेयर हुए थे। वो सारी चीज़ें जब आप लाएंगे तब आप ये कह पाएंगे कि अदालत को बता पाएंगे कि इस मिसल पे बहुत सारे ऐसे साक्ष्य मौजूद हैं जो इस आत्महत्या का बयान जो देते हैं वो आरोप से नहीं मिलता है, जो शो करता है कि वो लेडी वाकई ऐसे माहौल में थी कि वो मेरे दखल के बगैर, मेरे किसी दोष के बगैर आमादा हो जाती है अपनी ज़िंदगी लेने के लिए। कुल मिला के हम फैक्ट्स को, लॉ को, जज की साइकोलॉजी को, जो हमारे पात्र हैं उस नॉवल में, दोषी और गवाह, उनके मनोविज्ञान को सबको मिला के जब देखते हैं तब हम अपनी अपील को प्रभावी तरीके से तैयार कर पाते हैं।
Thank you, sir. And Mr. Sandeep, Mr. Manik, Mr. Abhinav Parv, and Sandeep Bhatia, we are sorry that because of paucity of time, we couldn't take all the questions. But God willing, we will come with another session from sir. If sir takes out the time, though, sir, we can only say that once you have done the session, we have understood that it is more important that you should have quality rather than quantity, like what is written on the vehicle when it is delivered to the customer, where it is written Q and Q, quality and quantity assurance. So that you have showed. And we have also taken your intakes that while they say that you have to filter the facts in a pyramidical shape. You said that 3 judgments are very important, though again, slightly off my cuff, that Prabhu, Rishikesh and Vijay. So you said that if you remember the Prabhu, that you can be in Rishikesh, plus you will get the Vijay in the session. And sir, after the session, I am only reminded, abhi na jao chhod ke, dil abhi bhara nahi. That's what the common sense is. And I am surprised that after even 1 hour, 15 minutes, people have started increasing their viewership on the YouTube channel. Plus, everybody was glued in this Zoom chat. That is the experience that you can actually mesmerize. And that's what you told us. कि भाई अपने शब्दों के जाल में लोगों को फंसाओ. It is even better than a spider. Thank you, sir, and we are so glad.
सबका धन्यवाद जी, आपका धन्यवाद.
And thank you to Tanu Bedi. She has ultimately held, like जैसे बिशन सिंह बेदी ने हमें बताया था, how to weave good balls. Thank you, sir.
Thank you so much.
बहुत बहुत
We hear so much about from sir on this session.